First case of the morning is State versus Riddlebarger. Each party will have 15 minutes to present their argument. The appellant members up to 5 minutes for rebuttal. How long would you like to reserve?
Yes, 5 minutes, please.
Okay. I'll keep the time up here, so I'll try to let you know you have about a minute left in your presentation. The arguments are being recorded. When you present your argument, please introduce yourself, come up to the podium, keep your voice loud, and do try to stay behind the podium because that way you'll be able to be picked up on the recording. You should not use the names of any children, minors, or victims during your argument. You can refer to them by initials or something like the child or the victim or something you think is appropriate for a matter. We've read your briefs and are ready to proceed whenever you are.
Your Honor, may it please the court, my name is Stephen Hanadel. I represent the appellant Robert Riddlebarger. This is probably maybe one of the most unique appeals I've worked on because a transcript couldn't be generated. So as you know, in a municipal court, there is no court reporter in the courtroom, so it's recorded on the court's audio recording system. It was burned to a disc, and the disc was provided to Anita Fine, who's a court reporter here in the Common Pleas Court for Judge Morelli, and she's been doing this a very long time, I believe 40 years, as it said in her affidavit, transcribed any number of trials, and including also muni court trials as well on the side, and she couldn't make out what the what the parties were, what anybody was saying in the on the audio, and she said, as she described, it almost sounded like they're in a different, the attorneys are in a different room. And then, but most importantly, the witness testimony was just indecipherable. And sure enough, and I provided a copy of the audio recording to this court in the motion to supplement that was granted. So it is in the record for you to listen to yourself. So if you can make out what the accusing witness is saying, by all means, please have at it, because the court reporter couldn't do it. I've listened to the audio, and the accusing witness's testimony is very muffled. You can hear the attorneys better than you can the accusing witness. Well, the attorney's words are of secondary importance compared to what the witness has to say on the stand, accusing Mr. Riddlebarger of domestic violence. So, we made the attempts. I mean, given the uniqueness of this case, this was a case of first impression for me, and this just does not happen often. So it really, just trying to tiptoe is like, okay, what would I do? How do I do this? And because there is some guidance from the 8th District recently in a case called McGurby, and that involved where the Cleveland Municipal Court audio recording system failed as well. So we did make an attempt. I had attorney Mike Kinlan, who's the trial attorney. He provided an affidavit to where he was able to at least provide a summary of just the basic gist of what was presented as far as the state's case, just the basic facts. But at the end of the day, the basic facts are not going to cut it. I mean, there's U.S. Supreme Court case law that says that the defendant, in order to fully exercise his right to an appeal, he has to have a complete transcript. I mean, there's just, you can't have it any other way. And and I know there's Appellate Rule 9. Now, Appellate Rule 9, the key language in there says may. And you have to at least make an attempt to engage Appellate Rule 9 to repair the record as best you can. But ultimately, Appellate Rule 9, I think it's not made for situations like this where you have such giant portions of the record that are indecipherable. Appellate Rule 9 is more suited for your isolated gaps where maybe you couldn't hear what the attorney said, or whether the attorney made an objection, and you need to fill that gap in. But when you're talking huge swaths of witness testimony, that is beyond the purview of what Appellate Rule 9 can do. And so the only remedy is just to send this case back for new trial. I mean, I know it's a drastic option, but Mr. Riddlebarger has a constitutional right of due process, and he has the right to an appeal under Ohio law, and and that right of constitutional right of due process attaches to that, and so. And like I said, there's case law from the U.S. Supreme Court that says in order for a defendant in order for his right to an appeal to be fully honored, there has to be a complete transcript, and you just can't have it any other way. And you know, the only time, you know, Appellate Rule 9 would kick in would be, you know, most of the transcripts there, and you just might have some isolated snippet, you know, maybe in one moment the microphone didn't work as well, and the attorney's words were hard to hear, and, you know, they do an agreed statement and say, yes, I did object at that moment, and so on and so forth, or I didn't offer, or I offered a stipulation. That's where Appellate Rule 9 can come in, where you can just fill in a gap, and, you know, that's repairable. But this is, in this case, this is beyond repairable, and so when the record is beyond repairable, the only option is to send it back and do it all over again.
It sounds like you spoke to, if I understood correctly, the defense attorney in the case. Was there any contact made with the prosecuting attorney to see if they could help provide?
I did not make any contact with the prosecuting attorney. I figured they would have their ability, they would have their say to you know, provide their side of the case before the court.
Did you? I take it you didn't try to file any kind of a statement pursuant to Appellate Rule 9 saying the defense attorney said that, and we want the record to be this, and
I submitted an affidavit from Mr. Kinlan.
But so, that affidavit was just, we can't figure out what the record is.
Well, Mr. Kinlan did provide what he recalled, as far as the basic facts of what he recalled in the case, as far as the basic allegations, as far as, you know, that the allegation was that that she threw a mug, the accusing witness threw a mug at my client, and then, you know, eventually she accused him of putting his hands around her neck, but when you get in those details, now you start getting into, okay, well, what were the exact circumstances? Like, you know, how, like, was it gently put around her neck, or was it really extremely hard, or was there self-defense involved? You know, those details, those finer details matter in terms of whether he's going to get found guilty or not.
And because you're counsel on appeal, I take it you don't at this point know for certain what the issues might be on appeal. You would need to read the transcript and review that.
Yeah, because without the accusing witness's testimony is completely muffled on that audio. Is indecipherable, and so without her testimony, I can't make a sufficiency argument. I can't determine whether the state, you know, presented sufficient evidence to get past the Rule 29. I can't, you know, it's hard for me. I can't argue whether the state's, met their burden, or whether the evidence was against the whether the conviction was against the manifest way of the evidence. I mean, especially when we talk about a DE case, the accusing witness's testimony matters a lot, and especially there's no other corroborating evidence. There's no audio recording or video. You know, I believe, like in the McGurvey case, they had police, they had some police body cam footage involved in that case. So some of this is a case-by-case basis, where if you know, even if you have some parts of the audio failed to record or whatever, you know, there could be other corroborating evidence that fills in those gaps, as far as, you know, documentation or videos and audio and things like that. But we don't have that here. So, and perhaps if there was a, you know, let's say if this was where, let's say, a police officer, you know, witnessed the event, or was able to capture the defendant admitting to it while while it's on, his body camera is on, and you got the body cam footage admitted as evidence, might be a different conversation. But there's, you know, here it's the accusing witness's word against my client's word, and so we have to know exactly what she said under oath in order for this court to conduct a review. And so the facts of this case, you know, when we look at, you know, the incompleteness of the transcript in Appellate Rule 9, the facts of the case also matter as well, because when you don't have the very nature of a domestic violence allegation involves an accusation from, you know, the alleged victim.
You have 1 minute left.
Okay. And so, you know, the trial court determination hinges a lot, if not almost all, on her testimony. And so, and whether, is she credible or not, and did she present sufficient, is there sufficient evidence in her testimony or not, and ultimately for this court to conduct a review, we have to know exactly what she said, and that's just not decipherable. The court reporter couldn't determine it, and when you listen to the audio, it's very muffled. So I'll reserve the remainder of my time.
Thank you.
Good morning, Your Honors. May it please the court. My name is Scott Bowles, and I am here today representing the state of Ohio in my capacity as a certified legal agent. The state respectfully asks that this court affirm the conviction of Mr. Riddlebarger for 3 reasons. First, Mr. Riddlebarger did not take the appropriate steps to use the procedures outlined in Appellate Rules 9C and 9D. Second, Ohio courts in this circumstance have regularly presumed the validity of trial court proceedings when there is no transcript. Lastly, a transcript is not even necessary to resolve Mr. Riddlebarger's sole assignment of error. To my first point, it is well established that the appellant bears the burden of providing the trial transcript to the Court of Appeals, including any statements under Rule 9C or D. And when a transcript cannot be obtained, the Ohio Rules of Appellate Procedure provide 2 mechanisms by which one can be substituted. Those would be Ohio Appellate Rules 9C and 9D. 9C provides for 9C provides for a statement of the facts provided by defense counsel or appellate counsel, while 9D provides for an agreed statement between the parties. Either of these options, therefore, provide the court with something to look at, something to review. In essence, it provides a full record of appeal. Directly applicable to the case before us, in 2021, the 7th District in Village of Shadyside v. Gibbons stated that when there is not a transcript, there is no transcript substitute under 9C or D, specific assignments of error, that the conviction was not supported by sufficient evidence and was against the manifest weight must fail, because there was nothing for the Court of Appeals to pass on. They presumed that the trial court proceedings were proper. So that is an example of what it looks like when there is no statement provided under 9C or 9D. The validity of the proceedings are presumed. But this court has provided a roadmap in how to properly handle a situation more akin to this. In Re NA, a transcript could not be completed due to the poor quality of the audio recording. After receiving notice of this, the appellant asked another court reporter to take a look at it. After the second court reporter took a look at it and came to the same conclusion that the audio was indecipherable, counsel then interviewed the different members of the adjudication. They talked to the witnesses, they talked to the parties, and when that failed, the Court of Appeals ultimately ruled that that was sufficient effort in which a statement under Rule 9C or 9D could not be provided, and therefore it was remanded. Here, we don't have that. Here, counsel obtained affidavits from trial defense counsel. They never even spoke to the prosecutor. They never talked to the parties, to my knowledge, certainly not in the briefs. There's no record of them talking to the judges, the judge, as has been done in other cases, or the court staff. Here, all we have are an affidavit from one court reporter stating that she could not transcribe every bit of the recording, and we have an affidavit from defense counsel who could not remember sufficient facts. Now, I have not had an opportunity to listen to the court recording myself, and what you hear is largely accurate from what appellate counsel said. Now, there were, I believe, 5 total witnesses called. You can hear the attorneys very clearly through the first witness. The first witness called was the complaining witness. Now, you cannot hear the majority of her responses. They are very muffled, and oftentimes, I cranked up the volume, I couldn't hear that anything was being said. But the prosecutor's questioning was very revealing as to what that testimony contained. She largely recounted what the witness's answer was in asking her next question. Now, this does mean that in some of the longer responses in which the witness gave more of a narrative, you do lose some of that. However, the majority of the other witnesses could be heard even when the defense attorneys or prosecuting attorney was not. I believe there was an officer called, I believe there was another witness called, I believe Mr. Riddlebarger testified himself, and we could hear every word that Mr. Riddlebarger said.
Were the, other than the complaining witness, was the testimony of the other witnesses able to be heard and deciphered?
It's largely hit or miss. So the second witness called, I believe, was the officer. You could hear some of his testimony pretty clearly, some of it could not. It was kind of like, just kind of hit or miss. For the other witnesses, it was largely the same. The clearest witness that you could hear is Mr. Riddlebarger, and the least clear that you could hear is the first witness, which is the complaining witness. However, I believe the portions of the transcript that you can hear are sufficient in order for an agreed statement of the facts or a 9C statement to be generated.
In discovery, were there witness statements and police reports given to the defendant would have some indication of what comments were made by the officer and the investigation was and what the comments of the witnesses were?
It's my understanding that there was a police report. As far as witness statements are concerned, I'm not entirely sure what they are. To my second point, Ohio courts have regularly presumed the validity of trial court proceedings when no transcript can be obtained. The reason the appellant has the burden for filing a record is because the appellant has the burden to establish that the trial court erred. And when there's no transcript or transcript substitute, this court has held that the reviewing court has no choice but to presume the validity of trial court proceedings and affirm. This court has demonstrated that exact philosophy in City Financial v. Hudzik, 2003, State v. Howell in 2002, and the City of Cuyahoga Falls v. James. In each of those cases, a transcript could not be provided in the trial court. From there, had no choice but to affirm because they had nothing to pass on. They could not determine whether or not there were any issues, so they presumed that the trial court proceedings were valid.
One of those cases where the appellant were arguing a due process violation rather than just saying, here's an assignment of error I want to make?
So, in each of those cases, the assignments of error largely varied. For the most part, they were manifest weight and sufficiency of the evidence. I believe in one of them, I cannot tell you which at the moment, there was a due process claim, in which case they largely presumed nonetheless. And appellate counsel did mention McGurvey. I'd like to discuss that for a moment. It was based on very specific facts involving a situation in which there were some medical issues pertaining to McGurvey, the defendant, and the court explicitly stated in it that it was their reasoning in remanding was due to those very specific facts. They went further and said that the failure of a reporting equipment is not prejudice per se, and absent a transcript or alternative record under 9C or 9D, we must presume regularity in the proceedings below. Lastly, Ohio courts have routinely echoed language to the effect that when portions of the transcript necessary for resolution of assigned errors are omitted from the record, the reviewing court has nothing to pass on, and thus the court has no choice but to presume validity. As such, transcripts are only required when they're actually necessary to resolve issues on appeal. Here, there's only one issue on appeal, and that's whether or not lack of a transcript violates Mr. Riddlebarger's right to due process. This is an issue that can only arise on appeal. As such, no transcript is necessary to resolve this appeal. And Mr. Riddlebarger has not meaningfully advanced any theory as to how the lack of a transcript specifically implicates his constitutional due process rights. And this court should not construct such assignments of error for him, as this court has stated numerous times in the past. In conclusion, the state of Ohio respectfully asks that this court affirm the conviction of Mr. Riddlebarger.
Thank you. You have your full time for a call.
Okay, thank you. First of all, when it comes to making a sufficiency argument, I think it's when the accusing witness's testimony is indecipherable, where do you begin as far as like trying to, if I were to make an assignment of error and say, okay, the state presented insufficient evidence, oh, by the way, I don't know what the evidence was because I couldn't hear what she said. I don't think, don't think the appellant should be required to engage in make-believe or engage in speculation when, when we don't know what the evidence is. I mean, it's ultimately the trial court, it's the trial court's responsibility to adequately record those proceedings. Yes, the appellant has the burden, to generate a transcript from those recordings. It is on the appellant to, engage with the court reporter and say, hey, I need a transcript of this trial. That's fine, but the trial court doesn't do its part in the beginning to record the proceedings like it's supposed to. Then why should the appellant have to engage in some form of make believe and pretend and speculation when we don't know what the evidence is? And as far as it's not even possible to argue an assignment of error on sufficiency when that's 100% dependent on what the accusing witness said in her testimony, which we don't know what it is. So, the only thing we do know is just in general from what Attorney Kinlan could recollect in his affidavit. But but again, and even the same goes with manifest weight as far as whether Mr. Riddlebarger was acting in self-defense or not. There's just, when you have such an incomplete record, there comes a point where it's a total due process violation, meaning that this has to be sent back. And it's not even possible. It's not even possible to make the arguments that the appellee's counsel is saying that we should make. And and I don't think the court should hold the appellant to basically what would be an impossible standard of, just engage in speculation and argue assignment of error that you think would work. Well, that's almost then asking a lawyer to possibly breach his ethical duty as far as in the kind of arguments he makes to the court and whether he's being frivolous or not. I mean, no, and so it's before I'm going to know whether an argument is a good argument to make to the court. I need to see that record. So, the U.S. Supreme Court in two cases, in Balance v. Smith in 1977 and then Hardy v. United States in 1964, have made very clear that anything short of a complete transcript is incompatible with effective appellate advocacy, and a proper appellate review is impossible without a trial transcript or adequate substitute. And when we talk about adequate substitute, that's where Appellate Rule 9 offers, the potential pathway to come up with an adequate substitute, but it's not an absolute. Appellate Rule 9, again, the key words in the rule are may. Nothing in there says you must do this or you shall do it this way or do it that way. It just says may. Appellate Rule 9 just offers options that you can engage as a possibility to repair the record or come up with an adequate substitute. But the Appellate Rule 9 does not in any way say, if you can't come up with an adequate substitute, well, sorry, you lose. The Appellate Rule 9 does not say that at all. It's just merely offering a roadmap as far as to come up with an adequate substitute, if it is possible. But in this case, it's not possible. And just given the facts of the case, given the evidence that was presented, given that the most critical evidence, which is the accusing witness's testimony, was indecipherable, it's not possible for Appellate Rule 9 to repair the record to the degree it needs to be repaired or provide an adequate substitute to which to protect Mr. Riddlebarger's due process rights. So, as far as in the McGurvey case, which the opposing counsel says facts dependent, sure. I mean, I think with all these cases they're fact dependent, including this one where there is no other corroborating evidence other than the accusing witness's testimony, and so that's given the great dependency on her testimony as evidence, that's where that really raises the bar and makes it very almost impossible for Appellate Rule 9 to repair that. So for these reasons, given the type of case it is, and given that these are very unique in their nature because it is sort of case by case, and this doesn't come up often.
And I kind of know your time is up, if you would briefly.
I asked the court to reverse and remand for a new trial. Thank you.
Thank you very much, and I thank both of you for your presentation on behalf of the court. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of the court and will also be